What's up, everybody? Welcome back to the internet where your cesspool is my jacuzzi. My name is Lauren Neidigh, but if you're here, you probably already knew that. I'm not a lawyer. I'm not a judge. Obviously, I should say that before I read these documents to you, but, so I'm just going to give you my subjective opinion, and you guys can, form your own thoughts. Everybody, please be respectful in the comments. I just want to say that off the bat. I don't mind, obviously, people who have different opinions than me, but let's please be respectful to everyone around us. Even if you don't agree, you can talk about that without being a dick. All right. Everybody in the chat, if you could, it would really help me out, help my channel out if you could hit the like on your way in, like Teresa said. Thank you, mods who are here right now. So what's going on is I finally got a chance to go over all these court documents related to the gag order. And in those documents, I saw some information and some viewpoints that I hadn't seen before. And it kind of made me double, rethink my stance on things. And maybe you'll have some questions about it too. But it did answer some of my questions about the hypocrisy angle of like why Blake is fine, like letting out the New York Times article, but it's bad when Justin tells his side of the story. So this does kind of address that question a little bit. We have a few different documents here that give us some information. They're not very long documents. There's probably like 4 or 5 of them, and I'll go over them with you tonight. But I had not seen before that other cast and crew on the set of It Ends With Us had also made claims of harassment or unwelcome behavior against Justin Baldoni. And that's what's alleged in the legal filing by Blake Lively. Now, these are all legal filings that were going back and forth around the time of the gag order and like the video being released and the voice note. I think the voice note actually came after all of these, but the conference, the pretrial conference where they're going to address the attorney's conduct and the press surrounding the case is going to actually happen on Monday. It was supposed to be on February 12th, but it was rescheduled. So it's going to be Monday at 11 a.m. So I guess we're going to figure out soon whether or not there will actually be a gag order. And hey, everybody, I see people trickling in here. So thanks for joining me. All right. So I'm going to start with this document, the first document that was filed on January, I believe it was 21st. Give me 1 second. Got to zoom in a little bit. Okay. All right. Hopefully you guys can see that pretty well. I don't know if the text is big enough. If not, just let me know and I'll, fix it up. So, all right. So this document was a filing by Blake and Ryan's counsel in the matter of Blake versus Wayfarer Studios. And it's the first one in this series addressing the press stuff and the gag order, to my knowledge. I did go over the entire docket today. So, all right. On December 20th, Ms. Lively filed an administrative complaint with the California Civil Rights Department, the CRD complaint, a requisite step in exhausting her administrative remedies prior to filing suit. Immediately thereafter, through counsel, Ms. Lively provided the named defendants a copy of Ms. Lively's CRD complaint. At the same time, Ms. Lively also issued the Wayfarer parties a cease and desist letter, the first cease and desist, demanding that they immediately cease and desist all unlawful conduct towards the Lively Reynolds parties and their affiliates, including their harassing and retaliatory media and online campaign against Ms. Lively. So I didn't know there was actually a cease and desist sent before like the video and stuff came out. So that's news to me. But again, like I've been following this case like somewhat loosely. I haven't covered like every single aspect or every single thing that's come out, but it did pique my interest enough for me to look at the actual court documents. So yeah, some of this is a little surprising to me. And as you guys know, if you've been watching my coverage, based on what I've seen, my opinion leans a little towards like in favor of Justin. Like I feel like some of Blake's claims were disproven by the stuff that has come out. However, I acknowledge that I don't know either one of these people. I wasn't there. And there's, each side is going to cherry pick things that look, positive for them. So while I tentatively have like been on Justin's side, I guess you could say, I'm open-minded in that some of the stuff they write here is, something that I'm going to kind of take into mind and think maybe it's not as cut and dry or as black and white as I thought. So, all right. So the cease and desist was the first thing I was not aware of. Okay, cease and desist, demanding they immediately cease and desist all unlawful conduct towards the Lively Reynolds parties and their affiliates, including their harassing and retaliatory media and online campaign against Ms. Lively. Immediately thereafter, and virtually every day since, Mr. Friedman has given television interviews, appeared on podcasts, issued inflammatory written statements, and leaked information, including, remarkably, documents as banal as documents. Documents as banal as document preservation. Okay, demands to third parties, to the Hollywood press and tabloid media. Those statements not only continue the campaign of retaliation that was the subject of Ms. Lively's first cease and desist, but they contain numerous new false statements about Ms. Lively and others. A list of public statements issued by Mr. Friedman, which is surely incomplete, is attached as Exhibit B. On December 23rd, in light of repeated instances of Mr. Friedman making unprofessional and false statements about Ms. Lively and the litigation she had commenced, Ms. Lively sent a second cease and desist letter, this time directly to Mr. Friedman, attached here to as Exhibit C. And we have the exhibits at the bottom here, guys. The second C and D directly addressed Mr. Friedman's ethical obligations, notified Mr. Friedman, as well as the managing partner of his law firm, that he had defamed and engaged in further unlawful retaliation against Ms. Lively, and demanded that he immediately cease and desist from making further defamatory and retaliatory statements relating to Ms. Lively. Did any of the other cast and crew go to HR area and says, I don't know yet, we're going to get there, but I'm not sure yet? Okay. Right. The second cease and desist lays out Mr. Friedman's false assertions and the evidence contradicting them, as well as the text of the applicable California Rule of Professional Conduct. The second cease and desist further explained that Mr. Friedman's statements issued as part of an all-out media blitz to anyone willing to listen were unprotected by the litigation privilege. Since the Wayfarer parties and Mr. Friedman received the cease and desist letters, they have continued their harassing and retaliatory media campaign with almost daily media statements or other releases to the press. Earlier today, and remember this was on January 21st, okay. Earlier today, the Wayfarer parties leaked a video to the media that they have asserted is designed to refute the allegations made in the Lively case, even though those allegations are now before this court in not one but two federal complaints. They have further indicated that they intend to create a website to increase publicity around the exhibits filed in the Wayfarer case. In one of today's multiple statements, they stated that the website will contain all correspondences as well as relevant videos that quash her claims. As counsel for Ms. Lively has made clear, these releases only reinforce the claims Ms. Lively advanced in her original complaint and continue to advance the campaign of retaliation alleged therein. But there is a more fundamental problem with Mr. Friedman's litigation via press statement strategy. Okay. So I know Blake's team kind of said that the video that was put out reinforces Blake's claim. Justin obviously says it reinforces his claim. I tend to lean on the side of Justin there. I don't think that he was harassing anyway. He was just trying to be a director and an actor. I kind of felt like she was acting a little awkward. That was just my perception. That doesn't make me correct or my opinion better than anyone else's. I'm just letting you guys know that was my thought. So I tend to think the evidence that's been presented to the public kind of leans in his favor. But again, I digress. There's a lot here that I didn't know. So as Ms. Lively's counsel have attempted repeatedly to caution Mr. Friedman, federal litigation must be conducted in court and according to the relevant rules of professional conduct. Wayfarer's counsel have already been warned that Mr. Friedman's initial media blitz back in December violated various California state rules. His most recent statements, coming as they do on the heels of his having filed a federal complaint in this court, plainly violate Rule 3.6 of the New York Rules of Professional Conduct, which prevents a lawyer who is participating in a civil matter from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Okay. Here, Mr. Friedman is a lawyer participating in the civil matter before this court, yet he continues to make regular statements covered by Rule 3.6. His conduct threatens to, and will, materially prejudice both the Lively case and the Wayfarer case, by tainting the jury pool because his statements are deliberately aimed at undermining the character, credibility, and reputation of numerous relevant parties, and likewise includes information the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial. So as a layperson, I'm looking at this and I'm thinking, well, the jury pool is shot anyways. On either side, I don't know. So, like, either side could have tainted the jury pool, but I don't know. That's just me. Like I said, I'm just a layperson. I don't work in the legal field, so. All right. California rules or New York rules? Well, so Justin's federal case was filed in, it's in the New York court. Blake had filed a complaint in California, but these cases are being combined to some extent. Some of the lawyers will explain that better than I can for sure, because there's a lot I don't understand about legal procedure and all that. Okay. We got here. Where was I? There we go. Here, Mr. Friedman is a lawyer participating in a civil matter before this court, yet he continues to make regular statements covered by Rule 3.6. His conduct threatens to and will materially prejudice both the Lively case and the Wayfarer case by tainting the jury pool, because his statements are deliberately aimed at undermining the character, credibility, and reputation of numerous relevant parties, and likewise includes information the lawyer knows or reasonably should know is likely to be inadmissible as evidence in trial. Is that a rule? I had no idea. Oops, my bad. Thereby creating a substantial risk of prejudice not just for Ms. Lively, but for numerous other parties in the matters. Mr. Friedman's conduct is by design, not by accident, and this court should consider carefully his history of litigating matters in the press when evaluating his request to be admitted pro hoc vice filed earlier today. It is worth asking whether Wayfarer's lawyers have any intention of abiding by Rule 3.6, or whether they intend to continue selectively releasing evidence without context or an opportunity to be questioned on that evidence in the public domain at the same time they purport to litigate this matter in court. Rule 3.6, of course, requires parties to decide whether they want a jury of their peers to decide their claims, or whether they prefer to let the court of public opinion do so. Doing both at once creates an impermissible risk of interfering with the judicial process, and it is not tolerated under New York law or the law of any other relevant jurisdiction. The court may exercise control over its docket and litigants before it to avoid improper conduct by counsel, and it should do so here. Okay. The Lively Reynolds parties intend to seek an appropriate protective order to govern further proceedings in this case, but given the imminent harm caused by Mr. Friedman's misleading and selective statements and leaks, we respectfully request that this court schedule a hearing as soon as possible to address the appropriate conduct of counsel moving forward in these two related matters. So that will be happening on Monday. Okay. Here we have Exhibit A. Cease and desist demand. The undersigned law firm represents Blake Lively, Ryan Reynolds, and their related entities. Okay. I'm trying to skim over some of this stuff. The dispute arises out of actions by the Wayfarer parties to sexually harass Ms. Lively during the production of It Ends With Us. And to retaliate against her for raising concerns about such harassing and inappropriate conduct through a coordinated and malicious social media and press campaign, which was aided and abetted by the Wayfarer associates and designed to harm the Lively Reynolds parties and to portray them in a negative, false light. The matter. Okay. In particular, we have obtained extensive communications among and between you detailing a repulsive and ongoing scheme to harm Ms. Lively and the Lively Reynolds parties, including by targeting them for harassment and damaging their public image through a coordinated harassing and retaliatory media online campaign. Wow, I cannot talk tonight. I'm sorry, guys. Sometimes reading these things out loud gets a little tedious. I'm doing my best here. We know that collectively you work to create, plant, alter, promote, and even suppress traditional and social media content, including but not limited to content addressing the on-set hostile environment created by Mr. Baldoni and Mr. Heath. We know that, for example, you work to suppress stories that would have revealed HR complaints with the foreign majors, and coordinated to plant and shape stories that were published in the Daily Mail, Business Insider, and Page Six. We also know that via contract with Mr. Wallace and his digital team, you have paid third parties to seed, manipulate, and then recirculate content designed to harass, intimidate, and disparage Ms. Lively on platforms such as Reddit and TikTok, as well as others, pretending all the while that the content you were promoting was authentic user-generated content rather than content you had commissioned and paid for in the first instant. Wait, you guys are getting paid for this? What the fuck? All right. Let's see. We understand that you mistakenly believe that these efforts would be untraceable and would allow you to destroy Ms. Lively without fingerprints. But just as these efforts have come to light, rest assured that if you take any additional actions to retaliate against our clients, we will uncover and hold you accountable for those actions as well. Your actions against our clients were and are unlawful, as your own communications prove. When you launched the campaign described above, you were aware that Ms. Lively and other members of cast and crew had raised complaints of sexual harassment, a hostile environment, and/or unwelcome behavior by Mr. Baldoni and Mr. Heath. Indeed, as you likely know, Ms. Nathan and Ms. Abel bragged in writing, contemporaneous text messages, to be precise, about having killed stories that would have accurately reported on those complaints. All right, so this was the news to me. I did not know other cast and crew had raised complaints. So sexual harassment, a hostile environment, and/or other unwelcome behavior. So I'm not sure what went on there or how many cast members were involved. We're going to have to keep reading to find out more. Hopefully they will, mention more, but they might save it for court. We'll see. Okay. Further, you knew that Wayfarer by mid-November 2023 had agreed to a comprehensive set of protections to facilitate a return to production, which Wayfarer had agreed, in writing, were not only reasonable, but also essential for the benefit of all parties involved. To the extent, you have not recently reviewed the reasonable but also essential provisions that protections for return to production document to which Wayfarer agreed, including its robust anti-retaliation provision, you may wish to refamiliarize yourself with that document before you take any additional actions that will result in further liability for you and your associates. To be clear, we understand that certain recipients of this letter may represent themselves to be nothing more than service providers acting at the behest of their clients. While we appreciate that the Wayfarer parties ultimately bear responsibility for the actions described herein, a review of the relevant communications leaves no doubt that the Wayfarer associates directly and knowingly participated in conduct that offends human decency, basic ethical standards of your professions, and the legal regimes listed below. Damn, that's a harsh statement. Offends human decency. Damn. What do we not know? Like, there's got to be some crazy shit going on behind the scenes I know nothing about. All right. Sheep says, I feel like I never actually saw anything come out that was outright mean against Blake, only resurfaced things where she made herself look bad. I know what you're talking about, because I saw that too, and I was like, this is like old news. I didn't really care much for it. I was just kind of like, this is dumb. Like, stuff people said more than 5 years ago doesn't really bother me. And like, people can change so much in that amount of time, so like, I think I mentioned this before, but she, like, there was this resurfaced thing where she said the T word or something, and I was like, okay, well, it's not really that deep to me, to be honest. So I mean, she's not saying it now, so all right. Of course, you understood that from the get-go, as Ms. Nathan presciently warned, we can't write "we will destroy her," because imagine if a document saying all of the things that he wants ends up in the wrong hands. All right. And guys, again, I'm not like saying this did or didn't happen right now. I'm just reading the document. So I might chuckle every now and then, just set my own thoughts. Okay. In sum, your conduct has violated and continues to violate Ms. Lively's contract writer, as well as state and federal laws, both directly and as an aider and abetter of unlawful conduct, including but not limited to 1, sexual harassment, 2, retaliation, 3, failure to investigate, prevent, and/or remedy harassment, 4, retaliation, 5, aiding and abetting harassment and retaliation, 6, breach of contract, 7, intentional infliction of emotional distress, 8, negligence, 9, false light invasion of privacy, and 10, interference. with prospective economic advantage. This unlawful conduct must stop immediately. Please be advised that the lively rentals parties have exhausted any applicable administrative remedies by filing the enclosed complaint within the California Civil Rights Department. Please also understand that we have now obtained an immediate right to sue notice, which is also enclosed, and are prepared to commence litigation. For present purposes, we demand that you, 1, immediately cease and desist your unlawful conduct towards Ms. Lively and the Lively Rentals parties, and 2, immediately preserve and do not take any steps to alter or destroy any evidence that relates to the matter. State and federal law obligates you to comply with this demand to preserve evidence. This includes the duty to immediately direct all of your employees, agents, and representatives to safeguard relevant records and to create mechanisms for collecting the preserved records so they might be searched. Failure to immediately cease and desist all such unlawful conduct and to comply with this preservation notice may trigger significant legal consequences and a host of damages, including but not limited to economic and non-economic damages, punitive damages, attorney's fees, and costs. Good Lord, that's a mouthful. Okay. You must immediately cease and desist from engaging in, directing others to engage in, or assisting or supporting any efforts to harass, retaliate against, or damage the Lively Rentals parties and their public image, including but not limited to through the use of social media and press surrounding the film in any way whatsoever, including but not limited to through the use of digital media, social media, or content seeding with any print or online media source, blog, vlog, podcast, or internet platform, including but not limited to TikTok. TikTok is a cesspool. Instagram, Facebook, X, formerly Twitter, Reddit, YouTube, Snapchat. Snapchat, man, people are doing this on Snapchat, Threads, Blue Sky, LinkedIn. LinkedIn? This shit's going on LinkedIn? Or any other such platform. That's crazy. I don't go to LinkedIn to look for pop culture news. But that's just me, man. Hey, Rob, what's up? Hey, Steph. All right. Demand to preserve and retain all relevant documents and electronically stored information. We further demand that you take the necessary and appropriate steps to safeguard against the destruction of all documents or ESI in your possession, custody, or control that relate to or reasonably calculated to lead to the discovery of evidence related to this matter in any way whatsoever. That's intense. Materials related to the matter for the removal of all doubt relevant materials include any documents or ESI as defined below. Sexually explicit or other inappropriate or unwelcome actions. Communications by or involving any wayfarer parties related to formal or informal complaints or discussion about the work environment on the set of the film. Communications by or involving any parties about any of the Lively Rentals parties or staff working on the film. Contracts or agreements with any public relations, marketing, publicity firms, or other third-party firms or provider of any social media services, including but not limited to efforts to seed, influence, manipulate, boost, amplify, or engage with social media algorithms, narrative or virality, as well as the use of bots or inauthentic accounts. Not the bots. All right. So this is basically just saying like what materials have to be, stored and you have to like safeguard against it because these are going to be used in discovery. That's my understanding of this. Hang on. Yeah, preservation of documents, preservation of electronic information. We won't go through all of this. Conclusion. We hereby demand that you immediately cease and desist in engaging in the above identified conduct, ongoing or contemplated, and immediately implement the document preservation steps described above. Nothing herein should be construed as a waiver of any of the Lively Rentals parties' rights, which are hereby reserved. Exhibit B, I think, is relating to the second cease and desist or something. Hang on. Oh, no, these are the examples of the stuff that he did in the press. Hang on. Okay. In a statement to the New York Times, which was later published by various different media outlets, Mr. Friedman stated, "It is shameful that Ms. Lively and her representatives would make such serious and categorically false accusations against Mr. Baldoni, Wayfarer Studios, and its representatives, as yet another desperate attempt to fix her negative reputation, which was garnered from her own remarks and actions during the campaign for the film, interviews and press activities that were observed publicly in real time and unedited, which allowed for the internet to generate their own views and opinions. These claims are completely false, outrageous, and intentionally salacious, with an intent to publicly hurt and rehash a narrative in the media. Wayfair made the decision to proactively hire a crisis manager prior to the marketing campaign to work alongside their own representative with JonesWorks, employed by Stephanie Jones, due to the multiple demands and threats made by Ms. Lively during production. It was also discovered that Ms. Lively enlisted her own representative, Leslie Sloan with Vision PR, who also represents Mr. Reynolds, to plant negative and completely fabricated and false stories with media, even prior to any marketing had commenced. Even prior to any marketing had commenced for the film. The representatives of Wayfair still did nothing proactive nor retaliated, and only responded to incoming media inquiries. What is pointedly missing from the cherry-picked correspondence is the evidence that there were no proactive measures taken with the media or otherwise, just internal scenario planning and private correspondence to strategize, which is standard operating procedure with public relations professionals. And they're listing like where he stated these things. Okay, talking about PR. In a statement released at Deadline, Mr. Friedman stated, "I'm not going to speak to when or how many lawsuits we're filing, but when we file our first, it's going to shock everyone who has been manipulated into believing a demonstrably false narrative. It will be supported by real evidence and tell the true story. In over 30 years of practicing, I have never seen this level of unethical behavior, intentionally fueled through media manipulation. It reminds me of what NBC tried to do to Megyn Kelly and Gabrielle Union, and we all know how that ended up. Stand by." That right there, I don't know, like, that's just his, isn't that just kind of his opinion? Is he not allowed to say that? Like, it doesn't really go into any specific evidence or anything like that, or show any specific, I don't know. That's just that one statement, though. Hey, P. Mahone, what's up? All right. During an on-camera interview with NBC Nightly News, Mr. Friedman stated, among other things, "I am more than willing to take every single text message that exists out there, lay them out, put them on a website for the world to see, have them see the truth, and determine the truth for themselves." Okay, so this is just more of his statements, which we've all kind of seen because of the media campaign that's been going on. Both sides campaigning, kind of the media. But this is the second cease and desist demand. Dear Mr. Friedman, as you know, we represent Blake Lively, Ryan Reynolds, and their related entities. This letter serves to remind you of your ethical obligations, notify you that you have defamed and engaged in further unlawful retaliation against Ms. Lively, and to demand that you immediately cease and desist from making further defamatory and retaliatory statements relating to Ms. Lively. Lawyers are not publicity agents. Somebody tell David Jingers that. All right. We are required to follow a different set of professional standards than publicists and crisis managers. One of those standards is the prohibition against knowingly making factual misrepresentations, even when doing so would help defend or promote our clients' interests. As the California Rules of Professional Conduct mandate, a lawyer shall not knowingly make a false statement of material fact to a third person. A lawyer is required to be truthful when dealing with others on a client's behalf. A misrepresentation can occur if the lawyer incorporates or affirms the truth of a statement of another person that the lawyer knows is false. On December 21st, you issued a public statement to the press, contemporaneously with a leaked version of Ms. Lively's complaint, which at that point you had not been publicly disclosed. Oh, that's awkward. Okay. Apart from constituting further retaliation and defamation per se, your statement violated Rule 4.1 in multiple respects. So I guess the reason they're like mentioning California rules is like he's licensed in California. Is that it? Thanks for running through this, Lauren. Most of us see red when we try to read these documents. No problem, man. No problem. All right. Okay. Lively's complaint, which at this point had not been publicly disclosed, apart from constituting further retaliation and defamation per se, your statement violated Rule 4.1. For starters, your statement falsely asserts that there were no proactive measures taken with media or otherwise, that the representatives of Wayfair still did nothing proactive nor retaliated, and only responded to incoming media inquiries to ensure balanced and factual reporting and monitor social activity. These claims are false. As you know, Wayfair Studios teams deployed numerous proactive measures with traditional and social media and did much of that work before Wayfair had ever received incoming media inquiries. For example, on August 1st, before the film premiered, And well before Wayfarer had received incoming media inquiries to which to respond, Ms. Abel wrote to Mr. Heath that she had fully briefed a friend of 12 plus years who writes for People magazine, Fox News, In Touch, and Us Weekly, and that her friend was armed and ready to take the story of Blake weaponizing feminism to any of her outlets the minute we give her the green light. She hates Blake, has heard the story before, and will do anything for us. This proactive measure was designed to harm Ms. Lively's reputation in clear violation of the language of the anti-retaliation clause in Ms. Lively's rider, among other things, and took place before any receipt of media inquiries. Okay. And then they show the text there where Jennifer Abel sent that to Jamie Heath. It says, "Thanks for the call. Confidentially, I'm out to dinner with a friend of 12 plus years who writes for People magazine, Fox News, In Touch, Us Weekly, and she's fully briefed the situation and is armed and ready to take the story of Blake weaponizing feminism to any of her outlets the minute we get the green light. She hates Blake, has heard the story before, and will do anything for us, just FYI. So, ma'am, never put anything like that could get you in legal trouble in a fucking text message. Like, ugh. I mean, no matter who you agree with there, you gotta kind of think that the person who sent that text message just like wasn't thinking a little bit. Like maybe she was a little drunk, out to dinner with her friend. I don't know. Like, but that was a dumb thing to send. Yeah. All right. A few days later, on August 4th, again prior to the film's premiere, Ms. Nathan wrote to Miss Abel that she had been in touch with her friend, an editor at the Daily Mail, who Ms. Nathan reported was ready when we are. As with the outreach described above, this proactive media engagement occurred prior to the alleged incoming media inquiries that later arrived. Okay, Melissa says, "Am I already off the records? Spoke to the editor Daily Mail because she's my friend. She's ready when we are." So I would love to see the context of this conversation because I mean, that could really be misconstrued. But at the same time, yeah, I can see why it looks bad. Especially the before text message where she's talking about the writer friend who hates Blake. Like, that is a bad look. I would not have sent that text message. So, all right. As you know, the next day after this, Mr. Baldoni sent a screenshot of an article accusing a prominent female celebrity of bullying and told Ms. Abel, "This is what we would need," to which Ms. Abel responded in the affirmative and mentioned her plans to work with Ms. Nathan on social and digital media platforms to accomplish Mr. Baldoni's objective. Huh. Okay, so his text says, "Yes, I literally just spoke to Melissa about what we discussed last night for social and digital. Focus on Reddit, TikTok, Instagram." What, not LinkedIn? I thought we were worried about LinkedIn, guys. Okay. Of course, as you know, Ms. Nathan's written plan expressly discussed engaging in proactive rather than reactive media techniques. Okay, here's another one from Melissa Nathan to Jennifer Abel. "Hi, Jamie and Jen. So incredibly glad that the press went so well today, and from what I know, Justin felt incredibly supported. He's lucky to have you all." This is June 8th. Okay. "We took the day today to do some research and get digital quotes in from the two teams we use to get the best results. As you are both aware, we are in a predicament that we just do not know the outcome of right now. Saying that, full transparency is key here. We have seen the most innocuous issues turn giant due to socials, or the hugest crises have no effects on social whatsoever. You just cannot tell at this stage. But Blake does have some of the Taylor Swift fan base, so we will be taking it extremely seriously." I mean, that is the reason to take it extremely seriously. Taylor Swift fangirls are hardcore. Okay. "We also understand audience is not solely Justin fan base, but the studio, so it's covering all bases time." I don't know if she's making sense there. Quote 1, this will be for a 3 to 4 month period. It includes website to discuss full Reddit, full social account takedowns, full social crisis team on hand for anything, engage with audiences in the right way, start threads of theories. Huh. Quote 2, $25K per month, minimum 3 months as it needs to seed, same as above. So they're just talking about like their agreement there. Okay. "Your statement misleadingly characterizes these kinds of communications as just internal scenario planning and private correspondence to strategize. But the implication of that claim, that none of these plans and strategies were ever implemented, is demonstrably false. So looking at that, I could see that as being like internal planning and whatever. Okay. Yeah, okay. Instead, your client retained a digital team, including Mr. Wallace, to engage in social manipulation and social media mitigation and proactive fan posting. On August 7th, Ms. Abel wrote to Ms. Nathan about needing to put the social media combat plan into motion. Oh no. God, somebody take this girl's phone away. She's doing the worst. Like, quit texting this stuff. This is when you like leave a suspicious note for someone and meet in an alley somewhere. Like, just stop it. And I know maybe they didn't do anything wrong, but at the same time, like some of that stuff, it looks bad. So I'm like, I probably wouldn't have put that, in writing. That's just me. All right. And then here's the text. Oh, it's from Jennifer to Melissa. Okay. I think we really need to put the social combat plan then into motion. Okay, so that's... Okay, so she said, so do I. Okay. Emails suggest that your clients met with Mr. Wallace the very next day, on August 8th. In an email to Ms. Nathan and Mr. Wallace, Ms. Abel wrote, "Tag team, is this something you can bring them up to speed on so they can hit the ground running?" Okay. On August 10th, your clients messaged each other about the results the plan and Mr. Wallace's work in particular had yielded, noting a shift on social due largely to Wallace and his team's effort to shift the narrative. Okay. So this is from Jennifer again. "Hi, team. So far, extremely limited..." Why did I say it like that? Hi, team. Okay. "Hi, team. So far, extremely limited pickup on Daily Mailer page 6. We'll continue to keep an eye out and send pieces as needed, but so far it's been steady coverage on pure speculation. We've also started to see a shift on social, due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. Again, we'll continue to send leaks and screenshots, but wanted to send an update in the meantime." Okay. Well, that could mean a lot of things, shining a spotlight on Blake and Ryan. I'm curious. Okay. In the days that followed, your clients regularly discussed amplifying, boosting engagement in the comments, and flagging to Mr. Wallace online content that favored Mr. Baldoni and disfavored Ms. Lively. For example, with knowledge that the marketing of the film was expressly following Sony's marketing plan, which Mr. Baldoni himself had followed prior to August, the Wayfarer team targeted and then amplified TikTok videos that mistakenly blamed Ms. Lively, rather than the marketing plan, for not speaking about domestic violence in the press surrounding the release of the film. Wait. Okay, why would the marketing plan involve her not speaking about domestic violence in the press? That's a terrible marketing plan. No, that's a terrible marketing plan. The movie is about domestic violence. The book is about domestic violence. Like, that just seems stupid to me. But if it's true, then it's true. I don't know. On August 18th, Ms. Nathan described the work of Mr. Wallace and his team as doing something very specific in terms of what they do. What? And confirmed that Mr. Wallace and Mr. Heath connected on this the day before. Ms. Nathan made it very clear that Mr. Wallace's team did not use bots because bots look fake to anyone. True story. And any digital team these days is far more intelligent to utilize something so obvious. Okay. This is fully consistent with Ms. Nathan's description in an earlier message that the digital team's effort to change the narrative would be untraceable. Okay, who here is guilty of using bots? Not recently. Just when I was younger and Instagram just started to be a thing, I was like, oh my God, I have no likes, so I got some bot likes. Sue me. Don't sue me. I don't have $400 million. Not that I would ever do what these people are doing on either side. Worse, you've been aware of your client's campaign against Ms. Lively since it began. We understand Wayfarer and perhaps others retained you at the same time that this retaliatory campaign was launched, and that you have been planning your response to Ms. Lively's claims since that time. Thus, the falsity of your statement was not only knowing, it was almost certainly premeditated. Okay. Sorry, I'm looking at this text they included right here. Bots and fan accounts also run pretty organically by now with all the AI platforms and Google Analytics itself. There's no bot army that's a myth these days. Any digital team these days is far more intelligent to utilize something so obvious. And your statement is particularly egregious given your friendship with Mr. Wallace, who you know is not in the business of reactive press engagement. Indeed, it seems that you are very close with Mr. Wallace, which suggests that the discovery will reveal your knowledge of his proactive social media influence work on behalf of Wayfair since August 2024. You are therefore not just potentially liable for defamation, but in Ms. Lively's existing complaint, you are a fact witness, likely in possession of documents and information relevant to the retaliation campaign alleged therein. Further, to the extent, as suggested in the message below, that you have been communicating with Mr. Wallace and other members of the Wayfair team via Signal, you are hereby on notice that you are legally obligated to preserve those communications. Your statement constitutes defamation per se. Relying upon the false factual allegations above, you falsely allege that the complaint Ms. Lively filed with the California Civil Rights Department is completely false, that the allegations contained in that complaint are categorically false, and that Ms. Lively filed the complaint with an intent to publicly hurt and rehash a narrative in the media. The necessary implication of your statement, therefore, is that Ms. Lively has made knowingly false factual allegations in a verified pleading to a state administrative agency, which, if true, would be a crime under California state law. That is per se defamatory, and the fact that you are a lawyer purporting to defend your client in public does not immunize you from defamation liability. Because you made these false statements in a functional press release to media outlets around the world, which you released alongside a leaked version of the complaint, which had not yet been publicly disclosed, you have forfeited any privilege from suit under California law. We accordingly demand that you cease and desist from further defamation of our client and that you take steps to preserve all your communications relating to your statement, including, without limitation, all documents, electronically stored information, and metadata in your possession, custody, or control that relate to or reasonably calculated to lead to the discovery of evidence related to this matter in any way. All right, so that was the initial stuff with the cease and desist. We have their response and the filings that came after that. They're not as long as this one. But I want to see if they say anything further about the allegations by other cast members or crew members that allegedly said Justin harassed them or had like unwelcome behavior towards them. So we're gonna look into that. Justice for Clayton. Hey, how's it going? What's up? Okay. So that was January 21st in that filing. This is January 23rd, and it's from Justin's representation. All right. As counsel for Wayfarer Studios, it ends with us, Justin Baldoni, Jamie Heath, blah, blah, blah. We write in response to the letter dated January 21st concerning alleged extrajudicial statements. And this is only 2 pages, guys. Contrary to the inflammatory allegations in the Lively party's letter, counsel for the Wayfarer parties has not violated Rule 3.6 of the New York Rules of Professional Conduct. Rule 3.6 prohibits a lawyer who is participating in a civil matter from making extrajudicial statements that will have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter. Putting aside that no such materially prejudicial statements have been made, Rule 3.6 creates an exception that allows the lawyer to make statements required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Huh. Okay. Well, that kind of makes sense to me. Maybe these lawyers are just really good. I don't know. The Lively parties provided the New York Times with Ms. Lively's otherwise confidential administrative complaint filed with the California Civil Rights Department and thousands of pages of original documents, including text messages and emails. Okay, and they're citing an article there from the New York Times. Okay. In its bombshell story, "We Can Bury Anyone Inside a Hollywood Smear Machine," the Times regurgitated Ms. Lively's allegations along with an array of cherry-picked, altered, and misleadingly spliced communications. The results have been utterly calamitous for Mr. Baldoni and the other Wayfarer parties, who instantly became objects of public scorn and contempt. Already, the Wayfarer parties have been exiled from polite society and suffered damages totaling hundreds of millions of dollars due to Ms. Lively's scorched earth media campaign. I mean, I would say they're both kind of scorched earth at this point. I mean, whatever. The coordinated public drop of Miss Lively's administrative complaint and the Times story, which the Lively parties do not deny orchestrating, began a very much ongoing attempt to rehabilitate Miss Lively's image at the Wayfarer party's expense. Immediately after the Wayfarer parties filed their complaint against the Lively parties, counsel for the Lively parties described the lawsuit as another chapter in the abuse playbook. That's true. I remember them saying that. And Mr. Baldoni as an abuser. Okay. As recently as 2 days ago, the Lively Party's counsel publicly described the contents of video footage relating to Ms. Lively's allegations as damning. Their statement continued, "Any woman who has been inappropriately touched in the workplace will recognize Ms. Lively's discomfort. In the context of a media feeding frenzy initiated by Ms. Lively, which has already caused and continues to cause untold harm to the person and professional lives of the Wayfarer parties, counsel for the Wayfarer parties adamantly and in good faith believe that a public response is required in order to avoid a prejudice to their clients. Rule 3.6, what's CMT? I don't know, CMT 7. Having publicly made ruinous allegations that the Wayfarer parties can prove are false, the Lively parties now invoke attorney disciplinary rules as an intimidation tactic. The Lively parties desire to force their Wayfarer parties to defend themselves privately against allegations made publicly is not a proper basis for a gag order. It is tactical gamesmanship, and it is outrageous. If, as the Lively party's letter suggests, such a protective order is formally requested, it should be denied." I'm seeing good points in both filings here, but, that's just me. Okay. Now, here is the response to that. And this came a day later. Okay. Counsel for the Wayfarer parties attempted to defend Mr. Friedman's extrajudicial conduct primarily on the basis that the Lively parties provided the New York Times with Ms. Lively's otherwise confidential administrative complaint filed with the California Civil Rights Department. And the Times regurgitated Ms. Lively's allegations. Okay. Counsel for the Wayfarer parties appear to be suggesting that the reference conduct is permissible because, in their incorrect and baseless view, Ms. Lively started it first. I mean, it kind of seems that way, to be honest. Again, just as a layperson, it does seem like she started it because she went to the Times, but they're going to explain here why that was okay in their view. All right. But the argument that they started it is misleading and ignores the reality that the utterly calamitous effects the Wayfarer parties claim to suffer as a result of reported facts and filed allegations were, on information and belief, initiated by the manner in which they or their counsel leaked the CRD complaint to the tabloid media. More problematically, it ignores that under well-established public policy and federal law, victims and survivors of sexual harassment and sexual assault have the freedom to report and publicly disclose their abuse. And then the footnote there is citing the Speak Out Act. Further, the position that the New York Times reporting on the CRD complaint permanently justifies engaging in provocative and prejudicial publicity distorts applicable ethical rules beyond recognition. Just as Mr. Friedman's initial and defamatory press statement to the New York Times was intended to fan the flames of controversy and move Ms. Lively's formal administrative complaint into the court of public opinion, and designed to focus on her character assassination, so have each of his public statements regarding Ms. Lively since that time. God, a run-on sentence is killing me. All right. This public commentary, including that he will sue individuals into oblivion, and will shock everyone who has been manipulated into believing a demonstrably false narrative, is nothing other than publicity, purposely initiated by the lawyer or the lawyer's client to perpetuate a public narrative of Mr. Friedman or his client's own creation. The Wayfarer defendant's assertion that no materially prejudicial statements have been made likewise cannot be reconciled with others of Mr. Friedman's public statements to date. Such repeated promises to take discoverable evidence and package it for publicity outside of the judicial context will materially prejudice the truth-seeking function of this court. Likewise, the claim that the Lively Reynolds parties seek a gag order is grossly misleading. So they're saying that they do not seek a gag order. Okay. This litigation is public. Requiring counsel to heed the ethical rules that bind them is not a gag order. It is a mechanism that would ensure the proceedings in this court are not prejudiced by counsel's conduct outside of the courtroom. The Wayfarer parties are attempting to draw a dangerous false equivalence that may have profound consequences not for just this case, but for other women who are sexually harassed in the workplace, given the high profile of this matter. These actions arose from one of the most fundamentally protected activities under the law, speaking out against sexual harassment and retaliation in the workplace. Making a complaint about sexual harassment and retaliation in a lawsuit, which is also a protected activity, is covered by the litigation privilege. On the other hand, relentlessly publicly attacking a plaintiff in a sexual harassment and retaliation case in the media and on social media is not a protected activity and is contrary to public policy and ethical rules. The Lively Reynolds parties have provided the court with the kind of language that the Wayfarer Parties Council has been using in the media on a regular basis, which is clearly designed to try to destroy Ms. Lively's character and paint her as a controlling, demanding bully who brought this on herself. Even more troubling, however, is that the retaliation campaign that Ms. Lively alleged in her complaint, with substantial supporting documentation, includes highly destructive behind-the-scenes elements, including the regular engagement of Melissa Nathan with her vast tabloid media sources to influence a steady stream of negative media regarding Ms. Lively, as well as a sophisticated and untraceable digital social media manipulation campaign designed to impact social media algorithms against Ms. Lively. The Lively Reynolds parties are informed and believe that these efforts have continued unabated since the CRD complaint was filed and may have even been accelerated. The administration of justice in this case will be severely compromised if this behavior continues. All right. And then the last document we have to go over came a couple days later, and I think this was after the video was put out. I'm not positive. It would have been after the video was put out or after the voice note was put out. So this was just like 3 days ago. I'm trying to check in on what you guys are thinking. Josephine Eichel, did I say your name right? Josephine Eichel. There's a lot going on behind the scenes. I agree for sure. I don't know. Like I've had a lot of thoughts going back and forth between these documents. So I had my opinions when I came into this, and then I read these documents, and I was like, well, now I'm a little confused, to be honest. I think both lawyers are making good points, but I'm a layperson. Like I said, I'm not a lawyer, so my perception of whether or not these are good legal points is going to be a little skewed. But as far as public opinion goes, and these are public documents, hence why I was able to get them. From a public opinion standpoint, I think maybe this does add a little bit of nuance or a little bit of gray area, like, because I understood it as they were just trying to silence him, and you know, like there was no basis for that. But I'm kind of like, I'm listening to what they're saying, and I'm really trying to keep an open mind. So I don't know, but like I said in the beginning of this video, my opinions have kind of swayed towards Justin's side. But you know, like I said, there's a little bit gray area here that I didn't really realize before. So okay. On Saturday, January 25th. So this must have been after the video then, not the voice note. Somebody correct me if I'm wrong in the comments. In direct response to filings from the Lively Reynolds parties to this court regarding Mr. Friedman's recent prejudicial extrajudicial behavior, Mr. Friedman issued additional inflammatory content to tabloid media outlets that contains multiple false and defamatory statements and character attacks against Ms. Lively. Those statements include, inter alia, 1, that Ms. Lively filed her California Civil Rights Department complaint, subsequently filed in this court, which was reported by the New York Times with the sole intent to ruin the lives of innocent individuals and then went the extra mile to place blame on a fictitious smear campaign. And 2, that Ms. Lively's sexual harassment and retaliation complaint has devastated the entirety of the domestic violence community. Mr. Friedman also falsely asserted that the Lively Reynolds parties have raised concerns about his unethical and unprofessional behavior only because Ms. Lively is fearful of the truth. They can't, as far as we know, and I'm reading a comment here. If you're just listening, they can't tell how much BL backlash can actually be attributed to. Okay, yeah, that's true. To Justin's campaign. Yeah. Oh my God, I hope no one heard that, but I have a new mic now that probably picked that up. I'm so sorry. Yeah, no, I agree. I mean, when she was doing her like press tour and all that, people were not impressed with her kind of behavior and the way she was going about that. So like some of that's going to be on her. So it is hard to tell, I guess. But they'll have to demonstrate that, I suppose. Okay. I'm going to take these off because I realize. Unless I have someone else on the stream, I always forget I don't have to have the headphones on. Okay. Mr. Friedman has made it apparent that he is engaging in this extrajudicial campaign to influence these proceedings and the public perception of legal filings to this court, and there already is a serious risk that his misconduct is tainting the jury pool. He further has made it clear that his priority is to torpedo Blake Lively's career for good by, among other things, creating a website to release strategically selected documents and communications between Ms. Lively and Mr. Baldoni. The planned website will release what Mr. Friedman self-servingly proclaims will be full unedited WhatsApp, text, and email exchanges between Lively and Baldoni, although neither the media nor public will have any way of knowing which communications Mr. Friedman has selectively omitted from disclosure, including communications that Mr. Friedman and his clients may have deleted. This website presumably also will not include communications that Mr. Friedman and his clients have had with their hand-selected media outlets and social media influencers during the past month, including certain of his current or former media and social media clients who either have hosted Mr. Friedman on air or parroted his narrative online. Any such website, therefore, will be incomplete, biased, and prejudicial by design. I understand the arguments here. I kind of get it, but selfishly, they brought this to the public, and now I'm invested, so I want to see the website. So, like from a legal standpoint, I can understand the arguments, but selfishly, from just a person standpoint, like release the text. You know what I mean? Like I just want to read it. But that's not realistically. Don't take my weird need for reading mess online into account. Yeah. Okay. Mr. Friedman's most recent statements, which are designed to leverage non-judicial channels to rebut filings made in this court, are not just improper, they are actionable defamation. Mr. Friedman is entitled, of course, to defend his client, but the law does not privilege the publication of knowingly false statements about Ms. Lively or any other third party to the press. That is precisely what he did this weekend. Mr. Friedman's repeated media attacks of a victim of sexual harassment engaging in a protected activity and his weaponization of media outlets to broadly disseminate these false, defamatory, and misleading statements have the potential to prejudice a jury pool beyond repair. This conduct especially is troubling here, where Ms. Lively's complaint alleges, with concrete evidence in the Wayfarer defendant's own words, that Ms. Lively suffered retaliation in the form of a coordinated online and media smear campaign at the hands of Mr. Friedman's clients, a campaign as to which Mr. Friedman and his law firm have now taken full ownership. Coming as it does on the heels of his $400 million lawsuit designed to sue the Lively rental parties into oblivion, this conduct reflects an effort to silence and intimidate the numerous potential witnesses who have first-hand knowledge of Wayfarer's misconduct, as well as a blatant, brazen violation of Rule 3.6. So that right there, we're going back to the other document where it said other cast and crew had accused them, both Justin and Jamie, of harassment or unwelcome behavior. So we regret that it is necessary to address Miss Friedman. They said Miss Friedman here, but I'm pretty sure they meant Mr. Friedman, unless Miss Friedman's been a bitch. I don't know, but we'll see. Ooh, wow, I should open that first. Mr. Friedman's misleading efforts to spin Ms. Lively's present request that Mr. Friedman and his partners follow the rules of professional conduct as a request to gag the Wayfarer parties because Ms. Lively is petrified of the evidence. That claim is designed to impugn Ms. Lively's character and thus is yet another violation of Rule 3.6. What is more, Mr. Friedman's accusation is incoherent. Ms. Lively initiated her lawsuit intending that the evidence relating to this case will come to light through discovery, knowing that the Wayfarer parties would have every opportunity not just to seek discovery from her, but also to defend themselves with any and all text messages, chats, or other documents that they believe proves their defenses. Moreover, what Mr. Friedman's communications ignore, and likely are designed to obscure, is that Ms. Lively is in possession of numerous additional communications relating to her claims against the Wayfarer parties. So that's interesting because we obviously haven't seen that. Like I've always said, there might be more that we don't know about. So that kind of piques my interest right there. That and the claims that other people had made harassment complaints. Okay. If Mr. Friedman's conduct is permitted, it will only result in an arms race of selective public disclosures of text messages to the media. Are we not already there? I mean, I feel like we're already there. That is neither encouraged nor permitted by Rule 3.6 or the parties, and in doing so, had a full and unencumbered opportunity to include in their pleadings any and all text messages or other contacts they believe supported their claims. When the Wayfarer parties consented to jurisdiction in this court, including by filing their own affirmative claims, they agreed that this dispute would be resolved under the federal rules of civil procedure and applicable rules of professional conduct. Those rules are crystal clear. Once a party is in litigation in a pending matter, it is unethical and improper for an attorney to use the press to attack the character of an opposing party or witness, including by releasing evidence that is subject to discovery. Not only has Mr. Friedman admitted that to be his objective. Okay. He also has now announced that he will continue violating 3.6. Further, he has caveated his claim respect for the court with a defiance of its rules, falsely suggesting that requiring compliance is akin to bullying his clients out of a defense. The endless stream of defamatory and extrajudicial media statements must end. It will not stop without this court's intervention. The Wayfarer defendants' efforts are being financed by a billionaire who has pledged to spend $100 million to ruin the lives of Miss Lively and her family. See Lively case ECF number 1. I haven't looked at that, but I need to. Oh, no, that's the initial complaint. Yeah, I have. Mr. Friedman is using that money, his roster of current and former clients, and a blatant media and social media strategy to assassinate Ms. Lively's character in advance of trial. Accordingly, the Lively Reynolds parties respectfully request a conference at the court's earliest convenience to address the concerns raised herein and in the Lively Reynolds parties' prior letters. Lauren, there, all right. You do have nice shiny hair. I have shiny hair. I must have missed that, guys. Sorry, I was busy reading. Let's see. What did Koala miss? I'm just catching up in your comments, guys. Lauren's hair is always so nice and shiny, dude. Well, I just showered before this stream, so that would explain it, I think. But thank you. So yeah, what I got from that, one of the important takeaway was, one, apparently she has, other people who came forward with complaints against him. I'll be interested to read more about that when that becomes available. It looks like she's not going to release that to the press. She's going to save that for court documents. And that this, gag order situation that'll be resolved on Monday. So that's just 4 days from now on February 3rd. So I guess we're going to find out soon whether or not, the lawyers for Justin's side are going to be restricted in what they can send to the media. There was a lot of nice tidbits in there that I had no idea about. I had obviously seen in the media that the gag order request was made, but I had only seen in the docket today some of that information. I feel like I hadn't really seen anyone else cover it yet, so I wanted to check and see if there was any new info and anything that might change my position or sway my opinion. And I don't know. I think it might be a little more black, less black and white than I thought it was before. Obviously, there's a lot that we don't know, and a lot that I don't, I hadn't considered. I'll say again, from what I've seen so far in the media, it does kind of push me towards Justin's side. However, I don't know these people. I don't know everything that went on. I don't know what happened behind the scenes that they have not released yet because they're waiting for court. So, like anyone, I'm just speculating. So everyone, please be respectful if you disagree. Let me know in the comments below what you think if you're watching this on replay. And thanks everyone for joining me. I'm going to take a short break now for about an hour, and then I'm going to come back and cover the Laura Owens appeal response with Schnitzel Ninja. So I will see you guys soon if you're here for that. If not, then I'll see you on the next one. Oh, the second podcast episode of my podcast, The Court of Random Opinion, is going to come out tomorrow. I'm not sure if it'll be morning or afternoon, but I will let you guys know. That'll be a member's first video, so when I post it on YouTube, members of this channel will see it before anyone else. So yeah, and I'll let you guys know when that's released. Thanks everyone, appreciate it, and I'll see you in an hour.